Hi, welcome back to the Law Cab. Thank you for tuning in today. So we're going to talk about public law, basically the concept of the rule of law. Okay, it's about Dicey and Lord Birmingham. So the importance of the rule of law is that it actually gives the importance of the UK Constitution because it's founded mainly on the rule of law. To observe the rule of law, there are 8 things that you must ensure that's happening in the Constitution. The 1, the government is prevented from exercising arbitrary power. Arbitrary power means abuse of power, because regular law is supreme. And the government is also held accounted for its actions through the judicial review. So there's no, that means they're not exceeding or abusing their powers granted. The third one is law is set out clearly for all its citizens and follows a set of procedure. Fourthly, law do not operate retrospectively. It just means a new law or act of parliament that's passed cannot punish for something that someone did illegally or crime committed before. Alright? And all citizens are equal in the eyes of law. Everyone is equal, and that everyone must have an equal access to the law, and there's no exceptions for whoever you are. Everyone deserves the right to access the law. Right? So the 7th point is like citizens have the means of a legal redress for their grievances. And lastly, independence of judiciary is maintained, and this focuses more on the separation of power to prevent the abuse of its use. Okay, so Dicey and Lord Birmingham definition definitely overlaps, like laws must be certain and concepts of equality before the law. There's an extra focus in Lord Birmingham's definition is on human rights and international law, but otherwise they definitely overlap each other. Dicey did not invent the rule of law. So some people have this conception that, Dicey invented a rule. He did not. So the rule of law was already there, but he popularized it in the late 19th century. And nowadays, specifically, it's mentioned in quite a number of sections of the Constitutional Reform Act 2005. Okay? So the first principle of Dicey is that no man could be punished or interfered by the authority unless the law has authorized it. A very landmark case for this, Entick versus Carrington, 1765. The government should not have such Entick premises as the law did not approve it, and he won the case. Brilliant. The second principle, equality before the law. That means this, for example, that everyone, if they've committed a wrong, they have to be going through the legal system. Everyone has a right, and they are all equal before the law. So no man is supreme above the law. Okay, that's why in the UK there's no separate courts for the government official, whereas in France they have this. I don't know whether I'm pronouncing it correctly, but basically it means direct administrative system where the government official has a separate court, but we in UK do not do that. The third principle is individual rights. There's no need for Bill of Rights as it's already respected. So what it's trying to say is they don't need a formal Bill of Rights to tell people that your rights are already respected. And the government does respect the personal liability because court protects them in their decision by developing common law in a way that respects individual liability, like in negligence of tort law, like what is the expected standards of a reasonable person. So of course, with like everything, there are always criticism. So the main criticism people commented on Dicey's rule of law is that he fails to deal with the supremacy of Parliament, and that in theory, because in theory it's the supremacy of Parliament, that he may pass whatever law he wishes. Even if an unjust law is passed, the courts can do nothing about it. But of course, the courts will do the best to interpret it, even if it is an unjust law. For examples that a court statutes can annul inconvenient court decisions is like the War Damage Act 1965, with reverse retrospective effect, the Burmah Oil versus Lord Advocate 1965, where the House of Lords ordered the government to pay compensation for the wartime destruction of its oil destruction. And some statute grants government officials some immunity from the legal action, like the Crown Proceedings Act 1947. Nowadays, government may effectively control Parliament if it has a Commons majority, right? So the like I told you earlier on Entick versus Carrington. So the opposite case for that was Malone versus Metropolitan Police Commissioner 1979, where Malone states no law authorized telephone tapping, but what the domestic court decided was there was no law to forbid telephone tapping by the police. Therefore, it must be legal. Do you understand the contrast? Yeah. So, of course, the last point I want to highlight under rule of law is that detention without trial breaches the Article 5, liberty of a person, and Article 6, a fair trial, right to a fair trial. So the House of Lords in A versus Home Secretary 2005, Lord Birmingham states, the claim to equality before the law, in a substantial sense, the most fundamental of the rights of men. A versus Home Secretary number 2, 2006, the House of Lords rejected the use of evidence received via torture, and it is unacceptable with common law traditions of UK, and as the best they can do, the judges will always uphold the rule of law at most. Alright, so that's rule of law in 7 minutes. Right, so thank you. Till the next time, if you like this, click like, subscribe and share. Signing off, the Law Cat.